Well, there have been yet another objection to the process conducted by the advisory panel that conducted interviews for the appointment of the new National Director of Public Prosecutions. Legal firm B Xulu and Partners Incorporated has demanded that the panel withdraw the letter sent to President Cyril Ramaphosa for consideration after it previously objected to the inclusion of Advocate Hermione Cronje to the interview process. This over a previous matter involving Kronje and the firm. It alleges that the objection was not taken seriously and that the panel was biased towards the former head of the investigating directorate. For more on this, I'm joined now by Newzroom Afrika's Zoleka Qodashe. Good to have you, and thank you very much for your time. Who are these lawyers?
That is, good afternoon, Tabo, and good afternoon to the viewers. The lawyers is essentially the legal firm of Barnabas Xulu. You'll remember him as one of the legal heavyweights in the country. And so they are taking this matter up with the advisory panel that conducted those interviews. You'll remember on the 10th and the 11th of December this year, there was that interview process that was conducted by the advisory panel that was instituted by the president, essentially looking to interview candidates for the next National Director for Public Prosecutions. And so the basis upon which they have filed another complaint or objection with the advisory panel is over what they say was the failure of the advisory panel to consider an objection that they had previously made and had filed timelessly. That objection is 99 pages, and they say that, you'll remember that during the interview process, at the end of that interview process, the candidates were given an opportunity to respond to some of the objections that were made against them for their interview for the NDPP position. And so in relation to Advocate Kronje, that objection was in relation to a matter that is of Arnold Benji's, who fled to the United States over those allegations and actually was convicted in relation to the Department of Agriculture, then former Department of Agriculture, Fisheries and Forestries and Fisheries. And so that is what the firm says was not taken into consideration when those interviews were conducted. And in fact, that the advocate, the former head of the ID, was given an opportunity to submit her representations or her response to that objection in a written response. But then on the 12th of December, the advisory panel then said that it had handed over its report to the president for consideration. So they say that even if that was the case, that she was allowed to have submit written representations, those were obviously not taken into account given how rapidly that report was given to the president for consideration. But it was a matter that was addressed by Advocate Kronje before the advisory panel. Let's just take a listen to what she says was the issue of contention in this matter when she was in the NPA.
Mr. Xulu and his law firm were appointed probably by the NPA, but also by the department to recover this money. So it was a curious appointment because I was no longer in the NPA at this point. But in fact, I was briefed in a civil matter by the NPA where Mr. Benjes was suing the government of South Africa for the full 21 million because he said that he had already settled with us with the 20 million, and so therefore we weren't entitled to the full 21 million. He lost that case. Mr. Benjes lost that case, and he appealed all the way to the SCA, I think. But Mr. Benjes's role then was to, on his version, recover on behalf of the South African government the 21 million, which, as I said, was curious because there were already orders in place that we were entitled to the money. But he and my former colleague, Knox Molele, traveled to Jersey and the United States and eventually concluded a settlement with that said we would take 7 million, not the full 21 million.
Now, in terms of the process, I mean, legally, is the panel obliged to make note of these objections? Legally, what does that entail? And have they done enough in terms of giving them a nod? Do they just say noted, ask the question, is that all that's really required of them?
So in terms of, you remember that this process isn't one that is guided by statutes or legislation, right? Because the president, in terms of Section 177 of the Constitution, doesn't need to institute such a process. So it is an ad hoc process, and the decision really lies with the president to appoint the head of the NPA. That's also in accordance with Section 10 of the NPA Act. Now, this advisory panel did take into consideration some of the objections, and what is actually detailed in the letter that was sent by the legal firm is that essentially this has been prejudicial to the other applicants or other candidates for the NDPP position, also prejudicial to the entire process. In fact, they argue that it renders the entire process to be irregular and unlawful for the failure to properly consider that objection.
All right.
But they also say that they are looking at taking legal steps because they're saying that the advisory panel must withdraw the report that is given to the president for consideration for the next NDPP.
Zoleka, Qodashe, appreciate your time. Thanks so much for coming.